All rise. The Court of Appeals Division 1 is now in session.
Thank you. Counsel, please be seated.
This is a time set for oral argument in our case, Baeurlen, and I'll look for correction on the pronunciation of that name, versus Arizona State Parks and Trails Department, CACB210182. Counsel, good morning. Our proceedings are being recorded, so please, as you begin your presentation, tell us your name. The clock is not that convenient thing that's right in front of you like it often is, but please understand why we have you spaced apart. Also, be careful with those podiums. If you push too hard, they kind of fold, so don't push too hard, I guess, is my suggestion for you. We did set this case for oral arguments on the court's own motion. We issued an order expressing some issues that we, at that time at least, and I think still had some interest in hearing more from counsel about. Each side is given 20 minutes for oral argument. Ms. Story, if you wish to reserve a portion of that time for rebuttal, you're free to do that, but you'll need to keep track of your own time. Out of respect to counsel, I would ask that everyone in the courtroom make sure your phones are off. That will also avoid any unnecessary or avoidable embarrassment. So with that, Ms. Story, you may proceed.
May it please the court, my name is Kirsten Story and I represent Appellant Arizona State Parks and Trails Department. I understand that I will be monitoring my own time and intend to reserve 5 minutes for rebuttal. This court has identified 4 questions to address in its order or setting oral argument, and so I am going to focus my remarks today on those 4 questions specifically and discuss each one in turn. So beginning with the court's first question, the plain language of Lemzic's final order, which you can find at Index of Record Appendix 1, demonstrates that the agency did, in fact, prove by a preponderance of the evidence that the agency had just cause to discipline the employee. Nowhere in the final order, or frankly anywhere in the record, is there any finding by Lemzic that the state agency has not proven by a preponderance of the evidence that the employing agency has had cause to discipline the employee as referenced in section 41-1830.16C2. Lemzic's final order sets forth exactly what it did. It says, and I quote, "A motion was made and seconded that the council find that the department had established that it had just cause to discipline Baeurlen." That motion was approved by unanimous vote of the council members in attendance. And the final order goes on to state, it is therefore hereby ordered and decreed pursuant to ARS sections 381106J and 41-1830.12F as follows. 1. Based on the evidence presented, the council finds that the department had just cause to impose discipline on Appellant Baeurlen. That is the sole finding in Lemzic's final order. Lemzic made no other finding on the record. And by law, there are no implicit or unstated findings. Under ARS section 381106K, Lemzic shall state in every finding of disciplinary action whether or not just cause existed for the disciplinary action. So if Lemzic were to conclude that just cause did not exist for the disciplinary action, in this case dismissal, it was required to state that in an explicit finding, and it did not. Likewise, under ARS section 381106L, Lemzic shall document in the record those circumstances where the hearing officer, administrative law judge, or appeals board determines that a party has violated a party's obligation under this section. In section 381106G sets forth the employer's obligation to carry the burden of proof in the disciplinary appeal, which under section 41-1830.16C and D is to prove just cause to discipline the employee by a preponderance of the evidence.
Counsel, let me ask you just more as a housekeeping matter than anything else. The council's reference to 1830.12 versus the briefing here of 1830.16, what's the interrelationship between those subsections of that statute?
411830.12, I believe, is the statute governing appeals from disciplinary actions of DPS employees. So LEMSIC also handles those appeals as well. But separately, the legislature has vested LEMSIC with the authority to hear appeals from full authority peace officers who are employed in the state personnel system. And that would be Mr. Baeurlen.
So this, and I know the council referenced, at least as I recall, point 12, but really it should have been point 16 here.
Correct. In this case, it would be point 16. For the purposes of this appeal, the provisions are substantially the same.
It looked to me like, the parties treated this as a point 16 case, but thank
Correct.
you. Please proceed.
Correct. Yes, I would say it's more of a typographic error. It doesn't really have a lot of substantive bearing on what happened in this case.
Thank you.
And is it typical to make a recommendation that the discipline be modified without a finding that there's not just cause for the specific discipline imposed?
Under the statute, it's not a possibility. And it's not permitted. So the LEMSIC is not authorized to do so, and in my experience, it's never happened before.
This is the first time where there's been a recommendation without a specific finding that there was not just cause for the specific discipline imposed?
In my experience, correct. So as LEMSIC made no finding that Arizona State Parks and Trails had not proven by a preponderance of the evidence that the employing agency had just cause to discipline the employee, as referenced in 411830.16C2, it had no authority to modify it.
We can't just find that it's implicit, since it says you may recommend modification if the state agency has not proven by a preponderance. And it seems like the only way to read that is not proven by a preponderance that there's just cause for the specific discipline imposed.
Correct. So LEMSIC's discretion to recommend modified disciplinary action, I believe we're moving into the third question, but LEMSIC's authority is conditioned upon a determination that the agency had not in fact met its burden of proving just cause by a preponderance of the evidence. And it cannot have implicitly made that finding under 381106K or 381106L. It must make those findings explicitly on the record. So since it failed to do so and failed to make that finding, and on the contrary, in fact, made the opposite finding that the agency had proven just cause by a preponderance of the evidence, it had no authority under 411830.16C or D to recommend modified disciplinary action.
Counsel, would that be no authority in a binding way or no authority whatsoever? In other words, I think one of the struggles, and I want you to talk about, if you would, the 1830.16 C and D, which I struggle with how they sort of fit together, but one of the ways to look at this case is it turns on whether the recommendations by the council were binding on the agency or were not binding on the agency, and I understand your position that they were not. But does that mean the council couldn't make recommendations, non-binding recommendations, say, hey, director, think about this when you ultimately impose discipline, even though it's not binding?
I think that any recommendation is going to be non-binding, but LEMSIC's authority to make any recommendation is circumscribed by the statute. And Facilitech makes it very clear that LEMSIC's authority is circumscribed and pursuant to statute. It cannot exceed what is outside the statute. And the legislature has made clear through 1830.16C and D what LEMSIC's authority is to make a recommendation. And it's not wide open and openly discretionary.
So if that's the case, though, and I'm looking, I viewed the council's paragraphs by number, and one is the finding that there had just cause to impose discipline. Mm-hmm. But sort of 2 and 3 and 4 are the recommendations. Your point is the council lacked any authority to do any of that.
That is correct. Under 411830.16C and D, as well as recognized in the principles in Facilitech, Arizona Board of Regents, in the cases that I cited in our brief, The agency's authority comes from statute. And so if the statute limits the agency's ability to make recommendation, provides the conditions under which the agency can make recommendations, then that is the scope of LEMSIC's authority. It cannot expand its authority by agency fiat, as this court and the Arizona Supreme Court have recognized. It's limited and circumscribed by statute. And the legislature was emphatic in 411830.16C2, and again in D, that there has to be a determination that the agency had not proven just cause by a preponderance of the evidence before it can go on to make a recommendation to the director, finding or otherwise.
Counsel, and I appreciate that. How, and I'm sorry, Judge Catani, how does 16C2 and 16D, how do those differ? I mean, they're obviously different text in different portions of the same statute, but they seem like they have enormous, if not complete, overlap.
I think there is substantial overlap. They're similar in that they confirm that LEMSIC's authority to modify the disciplinary action has to follow, by all means, a determination that the agency has not proven just cause by a preponderance of the evidence. I think that C2 basically provides the authority to provide the modification, and then D references the agency's ability to recommend proposed disciplinary action in light of the facts proven. So I can foresee, for example, in C2, a circumstance in which maybe the agency has proven some of the just cause factors, such as, all the material facts by a preponderance of the evidence, and the employee was warned, but perhaps the disciplinary action was disproportionate. And so we missed the fourth just cause factor under 381101(7)D, correct? And so in light of that, the agency hasn't met its burden of proving just cause, but a lower level disciplinary action is fit for the material facts. Whereas under D, perhaps there might be a situation where not all of the material facts have been proven, but some of them were proven. Some of the misconduct was proven, not all of the misconduct was proven, and so you can make a modified disciplinary action in light of the facts proven.
Can I ask one follow-up on that and then defer to Judge Catani? Wouldn't C2 more correctly, wouldn't it have been better if instead of modification of a disciplinary action, because by definition when C2 applies, the council has found there's no just cause, so there's nothing to modify. In other words, the council has found there can be no, or in other words, the burden was not shown to demonstrate just cause, meaning the discipline could not stand. Wouldn't some different word than modification be more instructive in application of that?
It's possible. I think that given that just cause is a multi-element concept, and that the just cause factors are written in the conjunctive, not the disjunctive, if an agency fails to meet its burden of proving all four just cause factors, it doesn't not necessarily automatically follow that the entire no discipline should follow. And frankly, I think that if we're in a situation where LEMSIC has concluded the agency has failed to meet its burden and no discipline is appropriate, the discipline should not stand. And we're more in a section.
That's under 3.
Correct. That there should be no disciplinary action.
So you're reading it to be just cause for the specific discipline imposed under 2.
Correct.
And if let's say the council had said that specifically, there's no just cause for the specific discipline imposed.
Correct.
The director then still has some discretion. How does the director meet presumably some kind of burden to say that decision was unreasonable?
So under 411830.16E, that sets forth the terms under which the director can accept, reject, modify, or reverse the findings or recommendations of the council, and that under those circumstances are if the council's recommendation is arbitrary or without reasonable justification.
Well, I get kind of arbitrary, but without reasonable justification. How would you ever go about showing that if the employee clearly did something wrong and all we're talking about is the degree of punishment warranted? How would the director ever be able to show what the council recommended was unreasonable?
I think that if there was a complete absence of justification for the council's recommendation, that would be a circumstance under which there's no reasonable justification, or in a circumstance where maybe the council provided a justification and that justification was not reasonable.
If reasonable people can disagree on the level of punishment, everyone agreed there was some sort of violation. But some people might think this person should be fired. Some people might think this person should be suspended for 3 weeks. Is there some standard that the director has to follow to decide if the board says 3 weeks is enough and the director thinks, no, it needs to be a firing? Is the board's recommendation necessarily unreasonable, or?
It's difficult to answer that, in the hypothetical. I can, as in this case, and we've explained in our opening brief, we think that this is one of those circumstances where the recommendation was both arbitrary and without reasonable justification under the record shown. And I think there are certainly circumstances in which the council can provide a recommendation that defies logical explanation, or even a reasonable explanation or reasonable justification. And so that is
But you're saying the burden is on the director at that point to show that it's unreasonable?
I don't think that the director has a burden, as this court has recognized in Lewis, but the circumstance has to exist that it is at least without reasonable justification, if not also arbitrary.
Are you saying they need both arbitrary and unreasonableness, or just one or the other?
It's one or the other, so it's
Okay.
arbitrary or without reasonable justification.
So LMSIC would have to find, in this case, no just cause to discipline, but then go on to say there was just cause for some discipline,
Correct.
and then they would have to give reasons,
Correct.
and the director could accept or reject in terms of final determination.
Correct.
And the rejection would only be if
It's
there was some
arbitrary.
element of unreasonableness that was found within the four corners of the record.
Correct.
What if the council just said it's unreasonable because it's too harsh? Is that just per se not a valid recommendation?
I think that if the council if the record reflected that this would be that the disciplinary action was disproportionate, if that is a reasonable justification, if it's supported in reason, supported in the record, then the reasonable justification standard would not be available to the
Supported,
director.
they have to show in other cases this is what's happened. What if they just have a gut reaction that this punishment just seems too harsh to us? Is that not, they can't say that? Assuming they've said, we find just cause, or there's no just cause for the specific discipline imposed, we think it's too harsh.
With no explanation.
No further explanation.
At that point, I think it's for the director to review and make his determination as to whether that is a reasonable justification in light of what has been provided to him. When LMSIC provides, a determination that is void of explanation or justification, then I think that leaves the recommendation open to potential modification or rejection by the director.
And just to clarify what I thought I heard in an answer to Judge Catani's question, you read C2 as dealing with just cause to impose the discipline imposed, correct?
Correct.
Where would I find that in that subsection?
Certainly. So, and I think this gets us to our second question, so thank you for prompting me into that. Under 41-1830.16 H5, just cause has the same meaning prescribed in Title 38, Chapter 8, Article 1. So that's Section 38-1101, which provides a definition for just cause under paragraph 7. And paragraph 7 provides 4 elements to just cause. Every single one of those elements must be proved, as this court has also recognized in Lewis. It's in the conjunctive, not the disjunctive. And 3 of those factors, B, C, and D, reference the disciplinary action, or the discipline, not a discipline, not some discipline, not any discipline. And so for the agency to meet its burden under 41-1830.16, it has to prove all 4 just cause factors. And this court has also recognized that in Lewis.
And my question, though, is that's for just cause, which by definition under Title 38 includes the discipline imposed.
Correct.
So how under C2 would you ever find, I mean, just cause includes the discipline. It's not a separate finding from the discipline.
Correct. So there would have to be, if we get to C2, there would have had to be a finding by Lemzik that the agency had not met its burden of proving just cause. And then, so that will enable the agency to recommend a modification. And then it's going to need to state every fact necessary to establish how the agency failed to meet its burden under 38-1106L. And so one of those factors is missing. And it could be the disproportionate factor. And so it would have to make that finding, and we would have to be clear on that, and then it can make its recommendation accordingly.
So there are not 2 findings, one just cause to discipline, and then the discipline. There's just one just cause.
Just one just cause finding.
Yeah, so paragraph 1 is just suggesting you have to make this inquiry. And paragraph 2 and 3 are the 2 options. Either there's no just cause for the specific discipline imposed, or there's no just cause for any discipline at all.
Correct.
So 1 isn't really anything other than saying it's your job to make this determination, and here are the 2 options, essentially.
Correct, although I would say, and I think this goes to the court's third question, that when Section C1 and C2 differ in that they provide the same question. They require Lemzik to answer to the same question, but C1 addresses the situation where, first of all, Lemzik must make the determination, but notably, if the determination is just cause, that just cause did exist, it's a full stop for Lemzik. There's no other authority provided to Lemzik once it does find just cause, that the agency did prove just cause. But C2 and C3 and D provide options for the situation when that C1 question is answered in the negative.
Thank you, counsel. We have peppered you with questions. I'll give you 2 minutes in rebuttal, recognizing your time has expired. Mr. Griffin, and please help me pronounce your client's name more appropriately. I'm certain I did not do so.
First of all, good morning. May it please the court. My name is Thomas Griffin. Ms. Story had a right to represent Brandon Baeurlen, the appellee.
Thank you.
I'm going to get into a little bit of background before I go into the court's 4 questions, because there are 2 issues here. And the first issue is whether the state applied an incorrect legal standard. The second issue is whether this law, whether the law allows the modification. And Mr. Baeurlen...
Well, you say whether there's the wrong legal standard, but aren't we just really looking at whether the trial judge erred in making the determination of whether the director had to impose a lesser penalty?
No, I'm addressing a different issue, because the law, and there are 2 laws. Because Mr. Baeurlen's a peace officer, the Peace Officers Bill of Rights applies, and so does 41-1830.16. Okay. And the state, the director, must follow the council's recommendation unless the director determines that not his initial decision to terminate, but the council's recommendation was arbitrary or without reasonable justification. The director didn't do that. He said, I'm not following it because his initial decision was not arbitrary or without reasonable justification. And so what he did was he addressed the wrong initial decision. He addressed, according to the Superior Court, the wrong question. And so he never even properly addressed the council's recommendation.
In your view, is there a specific finding that there was not just cause for the discipline imposed?
I do believe that there was that, and the Superior Court also addresses that.
But the only thing that I remember seeing is the council saying there was just cause.
You're right, Your Honor. It doesn't specifically say there's just cause for this or there's just cause for that. But when you look at it, I mean, you have to determine, well, what did they determine there was just cause for? And so, again, there are two statutes that apply to both issues. And on the second issue, on the modification, 381106J5 says there can be an administrative body that reverses a termination and instead imposes a demotion. And they can do it with or without pay. And that's exactly what they did here.
But they didn't seem to say that they were reversing it. They were saying, we find just cause, but we're recommending something less.
They didn't use the word reverse, but 1106J5 uses the word reverse. And so essentially, they did reverse it, they demoted him, and they demoted him without back pay. What they did mirrors 1106J5.
What do you make of the language that says if the director accepts our recommendation? Why have language like that if it's intended to reverse the director's decision and to say that there's no just cause? It starts looking like there was just cause. If it were us, we wouldn't necessarily have gone that route, but I don't see a statement that there wasn't just cause for what the director did.
There was not a statement of there was or was not just cause for any specific discipline. There was just cause for discipline. There was not just cause to terminate. There was just cause to demote. And I'm speculating on why the council used that language, but I think they use that language because they know that that's not the final decision. Pursuant to 1830.16E, the director still gets to look at that. He has to follow it unless it's arbitrary or without reasonable justification. So if he doesn't accept it because of one of those reasons, would be my speculation on why they did what they did.
But that would suggest that they're acknowledging that what we're doing is arbitrary and unreasonable, so he doesn't necessarily have to accept it. It seems odd to say if the director accepts this. It seems like if you want to say the punishment imposed, the specific discipline imposed, there was not just cause for that. Seems like that's a specific, something you should say specifically.
They could have written it differently. I think the statute could be written more specifically, but they know that the director, they can't control what the director does. The director has the ability to accept or reject it under certain circumstances, and even if what he does doesn't comply with the law, can't stop him from doing it. We just end up here. So again, I'm speculating on why they wrote it the way they wrote it, but that, it
seems odd. It seems like a superior court just saying, well, this is my ruling that will only apply if I'm not wrong. It seems odd. It seems more like just along the lines of I don't necessarily agree with what the director did and would like to offer that, and director, do with it what you may.
Certainly odd. I'm not going to argue with that. But they did make a recommendation, which they're allowed to make that recommendation. And he has to follow that unless it's arbitrary or without reasonable justification, which takes us to the first issue. He never addressed that recommendation. All he did was address his initial decision, and so he addressed the wrong question. So then we look at, does the law allow you to modify that? And what
Counsel, let me, before you go to that, and I want to hear from you on modification, but you've heard my struggles with the 411830.16C. What provision of that statute or any other statute do you read as allowing the council to find that there is just cause to impose discipline, but then make I'll call it semi-binding, absent arbitrary capricious action on what different discipline should be imposed?
And that's getting into the court's questions. And so I think C1 the court's question on C1 was, if there's a finding of just cause, does that mean that the discipline imposed was warranted? No. C1 has a two-part analysis. One, is there just cause to discipline at all? In some form is what the Superior Court used in its ruling. If there's not, that ends it. Then you go to 3 and they have to reverse. If there's just cause to discipline, then what is there just cause to discipline for? Okay. If it's the termination, then they have to uphold it, because the council has 3 options. If they find just cause for the discipline imposed, they have to affirm it. They have no option. If they find there's no just cause for any discipline, they have to reverse it. That's C3, 1830.16C3. The other option is, if they find just cause for some discipline, but less than the discipline imposed, they have the ability to modify it. Not only is that 1830.16C2, that's 1106J5. And then I had the same struggle with 1830.16D. I don't know that it's different than C2, but I think C1 and C2, and this was the third question from the court, are they different or are they the same? They're essentially the same, but C2 has an additional element. So in C1, is there just cause for any discipline? If there is, for what discipline? And then if you get into that analysis, you're at C2. What C2 does is it either adds or clarifies that you are allowed to modify it. I think all D does is say you modify it to fit the facts that were proven. So I think the statute would have the same practical effect without D. I think it's confusing that it's in there. I don't think it does anything other than clarify C2, but I went through that same struggle.
And I appreciate that. Let me ask, with respect to C1, just cause is a very inclusive term, particularly if we refer to 3811.01.7. It includes not only to discipline, but also that the discipline imposed is not excessive and is reasonably related. Tell me, you've described C1 as having a two-step. Help me better understand that, given the really broad, in my mind, definition of just cause that we find in Title 38.
It depends on what discipline you're looking at. So there can be just cause for demotion, but not just cause for termination, because the standard would be less. So the demotion would not be excessive for certain actions, which is what the council found here. But termination would be excessive for those same actions. So there would be no just cause to terminate, but there's just cause to demote for the same act.
And I think I'm with you, but I then struggle with the council's first paragraph saying had just cause to impose discipline. And that doesn't parse out, some discipline or, discipline, but not this discipline. I mean,
I agree it doesn't parse it out, but then it goes on, and this is, I believe it's page 6 of the Superior Court's ruling, discipline in some form. So the Superior Court went through and said there are 3 reasons why the modification is proper. And the first one, and this is it starts at page 5 and then it goes all the way through 7. The council's finding of just cause was limited to discipline, and I believe the quote is in some form. The council recommended against termination, recommended demotion, which is the only discipline for which it found just cause. And yeah, it would have been a lot easier on everyone if they had have gone through and specifically said that. It would be a lot easier if the statute was written sort of more specifically, but it's not. We have to look at what did they find just cause for. There's no indication that they found just cause to terminate. To the contrary, they found there wasn't just cause to terminate. There was only just cause to demote. And the statute C2 and J5 allow you to do that. And another thing that Superior
You're
Court...
just implying that by virtue of the fact that they made a recommendation.
But that's all the evidence that there is.
But a recommendation that just, it didn't seem like a very strong recommendation. We'd like you to think about this and provide a position if one's available, but not if there isn't one. It didn't seem like a very strong recommendation.
Why couldn't they have said we don't find just cause, but we find just cause for demotion, and here's why?
They could have.
And if they did, then probably we're not here because of...
Absolutely we're not here. And
okay.
They could have, and I think they said that without saying that. Because they said, They have a duty under the statute to make a recommendation, and they didn't use the language that probably everybody in this room would have used to make a strong recommendation, but they still made a recommendation by statute. The director didn't say there's something wrong with this recommendation, and they didn't go about it the right way. He said, I'm not going to follow it, and I'm not going to follow it because my initial decision was not arbitrary and capricious, which is, again, the wrong standard. So even if he looked at it, so then the only question is, does the law allow it? And the law does allow it, because another thing that the Superior Court said is when we look at J5, 1106J5, and 1830.16C2, if the law says, if the argument is that if there's discipline, just cause for discipline in any form, then you have to impose you have to give the discipline that was imposed, then those two statutes would be meaningless. The court went on to say, and I want to make sure I don't get the quote wrong, this is at page 7, that would lead to an absurd result that would make the council a powerless body and a rubber stamp. So we don't have specific language, we don't have a tightly worded statute. What we have to do is we have to look at everything that they put together, we have to look at all of the elements of both statutes. I mean, 1106J5 says exactly what happened here. He's a peace officer, he's entitled to additional statutory protections under the Peace Officers Bill of Rights. What happened with J5 is exactly what happened here, and according to the Superior Court, if we read it any other way, not only J5, but 1830.16C2, they're both meaningless. The legislator's not going to make meaningless statutes.
And counsel, let me ask you, you have mentioned the Superior Court's ruling several times, and it is detailed and thorough, and much appreciated. This court's review, however, is de novo of that. Do you agree?
I agree, but it's the same arguments. I understand. It's the same arguments that I made there, and I'm pointing them out because they're the specific arguments.
And so the director doesn't meet his burden because the only thing he addressed was the initial decision and didn't really address in any way what the council did.
Correct. If he's not going to follow that decision by, I think it's 1106K, and it's also 1830.16E, the only way he has to accept it unless it's arbitrary or without reasonable justification. He didn't even go down that road. He said, my initial decision to terminate was not arbitrary.
It's kind of hard for him, though, to come in and explain what's off about the council's recommendation if they say you, in fact, had just cause. They haven't said this is excessive because A, B, C, or D. They just said, no, the director, in fact, had just cause. It's difficult to come up with a coherent explanation for why that's unreasonable.
You've raised issues with their recommendation. He could have raised those same issues, and by statute, he had to raise issues with that recommendation, not his underlying recommendation. So we're getting into another issue of, could he have properly done this? He didn't even try to properly do it. He did it, he applied the complete wrong standard.
Counsel, you've heard appellant's counsel say this scenario, if you will, where paragraph 1 says just cause to impose, finding that the department had just cause to impose discipline, but then these alternative paragraphs 2, 3, and 4, the other recommendations, is unknown in her experience. Do you view it the same way, or are you seeing sort of counsel decisions like this with some frequency? And I'm asking you, of course, about the nature of your practice,
Sure.
if you'd be in a position to.
So, and I do I do a lot of post-termination hearings. This is the only one I've ever been involved that went to a hearing before this council. So
thank you.
I can't answer that question in front of this council.
I appreciate that. Thank you.
To sum up, unless the court has any additional questions, again, the council had 3 options. And if they look and they say, is there just cause first for the termination, because that was the discipline imposed. If they do, end of inquiry, they have to affirm. If there was no just cause for that, for termination, was there just cause for any other discipline? If there was not, then they have to reverse. That's C3. If there was just cause for some discipline in between, they can modify. That's 1830.16C2, 1830D, 381106 J5. Here, there was just cause, but there was only just cause to demote, and because of that, the modification was permissible. And because that modification was permissible and the wrong standard was applied by the state, Mr. Baeurlen respectfully requests that you affirm the Superior Court's decision, and unless the court has any additional questions, I don't have anything else.
Thank you, counsel.
Thank you.
Thank you. Ms. Story, rebuttal.
Could you address, sorry to jump right in, but could you address the significance of the director's statement that my original decision was reasonable? Why is that relevant to anything? If the council had said no just cause for the specific discipline imposed, does the director saying, no, my original discipline was right, has he met his burden or whatever burden there is to go against the council's recommendation?
I think that if that was the only reason stated in the director's decision, then that could be problematic. And we might be in a situation where the reasons for rejecting or modifying the recommendation would not be present. But that simply isn't the case here. The director provided multiple reasons for his decision to reject the council's recommendation. He started off with a recognition that the council had in fact found just cause for dismissal and adopted the council's determination of just cause. And so that starts off with his first reason for rejecting the recommendation. He goes on to provide multiple other reasons for rejecting the council's decision.
Multiple other reasons would leave a discretionary call by the trial court to either accept that or reject those. Doesn't your position pretty much turn on whether the finding that there's just cause kind of ends the inquiry?
I think it certainly does, because if there's just cause, that ends the council's authority to make any recommendation. And if it lacks authority, then it's without jurisdiction to do so, and it's void. So that provides, Director Broscheid was certainly not compelled in any way to accept or even entertain a recommendation that was made, oh my goodness, I apologize, without authority to do so. But nevertheless, he also provided reasons for doing so as well, as reflected in his full decision letter, which provides multiple reasons that do include that the original decision was not arbitrary. And that is a reason to maintain the original discipline. And so he did provide a reason. This doesn't reflect that he did not review Lemzik's decision for whether it was arbitrary or without reasonable justification. He directly refers to that in the paragraph right above that. And so I take strong exception to the suggestion that the only thing that he did was decide that his original discipline was right and then affirm it on that basis. That's not what the record shows. I realize I'm out of time.
2 minutes goes fast if you wish to
does.
wind up in a sentence or two.
Certainly. Just very briefly, the suggestion that 381106J5, which discusses the council's ability to reverse and provide back pay, simply doesn't apply here. The council didn't reverse. That is provided for under section 4118 30.16C3, and that only follows when there's a decision that there is no just cause for any discipline whatsoever, and that is certainly not what the council found in this case. I would also say that,
Counsel, I'm going to have to interrupt
right,
you, but
thank
we appreciate your presentation today. Counsel, we appreciate both of your presentations. We don't do this very often, and I have found argument particularly enlightening, and I appreciate that. We will take the matter under advisement, and we'll issue a written ruling in due course. With that, the court stands adjourned.